So when it comes to the FinCEN reporting, what are you supposed to do? Is our privacy really going to get busted when we start sending information, when title companies require information? I own a TC company and a title company, and I'm on the front lines of understanding and figuring this out. Now, as I read the regulation, I did see this technicality, and you see behind me Clint Coons. I love the guy. I love his content and his expertise. And I agree, there is a technicality in which you can make a transaction non-reportable. Somebody emailed me and said, hey, do I need to start putting all my properties in a trust to avoid getting reported? Is it going to bust my privacy? I've got a couple of angles here that I want to talk about. My intention is to go in depth, so I don't intend this to be too short of a video. But at a high level, yes, I agree there is a technicality that if you use a trust in a certain way to purchase a property or transfer into it, that it's non-reportable, and then the beneficial interest transfer after that is also technically non-reportable. Now, in my email response to the person who asked me this question, I said the fact that this guy, Mr. Clint Coons, is willing to endorse this method is a pretty strong vote of confidence in my book. I like it. But I have been investigating this, and it's pressing on a technicality. It's leaning on the letter of the law instead of the spirit of the law. That it being a new thing, I think it's up for a lot of debate. I don't want to be the one who's a test case. And so with that in mind, you have to ask yourself, are you prepared to face the consequences or defend your position for structuring a transaction that a judge could, in my opinion, they could pierce it when they look at the totality of circumstances? Because the person who's arguing against you is going to say, you specifically constructed this transaction. You structured it to evade reporting something that is a legally required, a legal requirement. Let me say that again. You specifically structured this transaction in a manner to evade reporting required information to the government. They're going to say that in the totality of circumstances that this was a transaction from a seller to your LLC. Okay? Just because you jumped it through another hoop first on a technicality. So this transaction from a seller to your LLC would otherwise be reportable. Therefore, just because you jump through a hoop to make some piece of it technically non-reportable, it is still reportable. And there are multiple laws that are interpreted that way, or even state and court decisions have stated that structuring something to be a technical avoidance of an otherwise existing obligation, that can stand. And so your technical avoidance is no avoidance at all if it actually gets brought to court. So is yours going to be the test case? Likely no. So make your own decision. But are you willing to face the consequences or defend your position if you're the test case? So I agree with the technical interpretation that the trust from a seller to a trust which they own is non-reportable. That's my opinion as well. I'm not an attorney. Clint Coons is. And I agree that the private transfer of beneficial interest in the trust after the deed transfers to the trust is a private non-reportable transaction. The next issue is it reportable, or does it bust my privacy? I don't have that big of a concern on the privacy side right now. Not that I trust the government to keep things private forever, etc. But if you own an LLC, the IRS government, aka, has your name associated with that entity. Does the public know? No. So other than data breaches, which I don't doubt, other than data breaches, people don't know that Caleb Christopher is associated with ABC LLC. Okay? So if I've done my privacy the right way using a Wyoming entity, etc., I'm reasonably confident that it is private, even though I had to give the IRS my name and report on my taxes, etc. That's non-public information. So am I worried that the FinCEN reporting is going to put my information on public record? No. What's the reason for privacy? Typically, I'm talking to real estate investors here. Typically, it is to keep yourself out of frivolous lawsuits. It is to show outsiders that you're not trying to be messed with, that you're actively trying to avoid being messed with. It is to deter slip and fall phishing people fishing for money. I literally had a letter a month ago at one of my rental properties where somebody claimed to step in a hole and injure themselves. It looked like a fishing expedition. It didn't have specifics. It was baiting us into saying something that they could use to pressure or to settle out of court. So we didn't give in to that, but that was an LLC that was not very private. I busted my privacy when I signed a document that ended up going on public record. So if you're looking for anonymity, I'm not concerned about FinCEN reporting busting that anonymity from the perspective of where it matters from a liability, a non-discoverability for liability purposes, for people chasing you down for frivolous lawsuits. I'm not concerned on that front. So am I okay reporting to FinCEN when I buy or sell a house? Yeah, I am. I am for now. Could that change later? Absolutely. And that's going to suck if it does. But I don't know a way around it other than jumping through this technical loophole, which I'm not willing to be the test case for. This is not AI sponsored. This is not AI powered. This is Caleb powered. And so this is my real opinion after reading content, doing research, etc., pulling in my past experience, having won in court before, having had to defend technicalities versus the letter of the spirit. I've been there and done that. This ain't no copy paste from AI. This is my thoughts. So there you have it. Make your own decision.